breaking news, and this one is sending shockwaves across America. The Supreme Court has just taken an emergency decision that could change everything we thought we knew about the Second Amendment. That's right. Reports are saying a motion is in place to end all firearm permits nationwide. Yes, you heard that correctly. Every single permit gone. Now, before you think this is just another rumor, stay tuned, because what's unfolding behind the scenes is far bigger, far deeper, and far more controversial than anyone expected. There's talk of political pressure, hidden agendas, and even private memos being leaked from inside the highest court in the land. What's really going on? Why now? And who stands to benefit from this drastic move that could reshape personal freedom, security, and power across all 50 states? The implications are massive, from the right to self-defense, to state sovereignty, to the future of law enforcement itself. If this decision goes through, we could be looking at the most radical federal overreach in decades, sparking protests, constitutional battles, and maybe even civil unrest. But don't blink, because the details are emerging fast, and some of them are absolutely shocking. Now, before we dive deeper, make sure you hit that like button and subscribe right now. Not just to support the channel, but because YouTube's algorithm is making it harder for independent voices like ours to reach viewers who actually care about the truth. When you subscribe and hit that notification bell, you're helping to keep real information alive, unfiltered, and uncensored. Trust me, you're going to want to be here when the next update drops. And don't just watch passively. Drop a comment below and tell me what part of this story shocks you the most. Do you think the government is overstepping its power? Or is this a long overdue move to control violence? Your voice matters here. This community is about discussion, not silence. So stick around until the very end, because the final revelation in this video, the one that's been buried in official documents and quietly circulating in legal circles, will leave you speechless. I promise, you've never heard it presented like this before. This isn't just news, this is history in the making. 1. The Supreme Court's shadow move, emergency authority, and the shadow docket. First, we must understand how the Supreme Court could even attempt such a sweeping change so quickly. The key is the emergency docket, often called the shadow docket, a procedure by which litigants seek immediate orders without full briefing or oral argument. Through this route, the court can issue and sign opaque rulings that take effect immediately, bypassing the usual deliberative process. That's what makes this claim of ending all firearm permits plausible. It's not being argued through the normal full case path, but via an emergency motion. If a majority of justices agrees, they can temporarily freeze state permit systems or force new standards nationwide. The danger is that such decisions often lack transparency, leaving huge legal uncertainty. Critics warn that this power can be abused, used to upend rights or regulations before states or lower courts even respond. So this entire scenario, a nationwide permit end, almost certainly must ride on that shadow docket mechanism. 2. Constitutional and legal basis. How could they justify nullifying permits? Assuming the court does act in emergency fashion, what constitutional theory could support voiding every firearm permit regime? The root lies in Second Amendment jurisprudence post-Bruin, New York State Rifle and Pistol Association versus Bruin. Under Bruin, governments must show their regulations align with the nation's historical tradition of firearm regulation, not merely modern considerations. With that logic, the argument might go, permit systems are modern inventions with no analog in early America, so states may lack constitutional authority to demand them. A more radical version might treat carrying firearms as a fundamental right unburdened by permit constraints, demanding that all permit systems be struck as unconstitutional. They may also invoke Commerce Clause or federal supremacy arguments, that the federal government or Supreme Court acting for the Union can override state permit laws in a national emergency. However, opponents will counter that states have police powers to regulate public safety, and permit systems have a historical pedigree, e.g. colonial or 19th century licensing laws, that could pass Bruin's test. The legal fight would be ferocious and likely to land back in full merits arguments. But in emergency mode, the court might just impose a stopgap ruling before those debates are fully aired. 3. Immediate effects across states. Chaos, legal vacuum, and conflicting state responses. If a nationwide order voided permits, the result would be legal chaos. States with strict gun control regimes, those requiring background checks, training, character review, disqualification of those with criminal history, would suddenly find their enforcement tools undermined. Permit holders, aspiring applicants, and law enforcement would be thrown into confusion. Do people now legally carry guns without permits? Or do local laws still bind them? Some states might refuse to comply, fighting in court, creating patchworks of enforcement. Others might scramble to impose emergency local permits or new regulations. In border zones, citizens and travelers would face conflicting rules. Police departments would be uncertain when to arrest or detain someone carrying a firearm without a permit. Insurance companies may reclassify gun liability. Lawsuits would flood district courts. The fallout could be immediate. Increases in gun raw carry incidents, law enforcement uncertainty, and surges in civil lawsuits. 4. Public safety versus rights clash. Empirical evidence and risk of violence. While gun rights advocates will herald the move as liberation, many public safety experts and studies warn of serious downsides. For example, research shows that shifting to shall-issue permit regimes, i.e. less restrictive requirement removal of local discretion, correlates with increased handgun purchases, especially repeat buyers in high-crime urban areas. A 2022 analysis found that jurisdictions removing concealed carry permit requirements reported a 12.9% increase in officer-involved shootings. The loss of vetting, background checks, safety training could allow individuals with risky histories to legally carry guns in public. Gun violence advocates contend that permit systems serve as filters against irresponsible carriers. Meanwhile, opponents accuse permit regimes of de facto discrimination, delays, or burdens on law-abiding citizens. But the data gap is real, long-term studies are incomplete, and many variables, crime, policing, social changes, complicate cause and effect. If a blanket permit abolition passes, though, society may be forced to live through the experiment, with lives and security at stake. 5. Political motives and interest groups. Who gains and who pushes? We must ask, who stands to gain from this radical move, and what political forces are pushing it? Gun rights organizations could consolidate their influence, framing an existential victory for the Second Amendment. Politicians aligned with deregulation agendas might use it to galvanize their base. The push might come tied to proposed federal bills. For example, the Constitutional Concealed Carry Reciprocity Act, which would force states to honor concealed carry permits from other states, further weakening state control. Deregulators may view this as the next frontier. Once permit systems go, then amplifying open carry, looser background requirements, or weaker licensing in general. Conversely, gun control groups will mobilize lawsuits, grassroots efforts, protests. State attorneys general and governors in restrictive states may resist. The political theater will be intense. Behind the scenes, leaked memos, private court communications, or political pressure on justices might emerge. The narrative could become not merely about law, but about power, ideology, and the future of American governance. 6. Legal challenges, state resistance, and constitutional reckoning. Even if the Supreme Court issues an emergency order, it cannot end the battle. States, public interest groups, and lower courts will respond swiftly with injunctive challenges, appeals, and counterclaims. Some states may blatantly refuse compliance, leading to constitutional standoffs. The federal-state tension over police powers will be front and center. Can a Supreme Court order invalidate state permit systems? Or are these state prerogatives immune to abrupt nullification? The full merits process will have to grapple with historical evidence, comity, separation of powers, and whether sweeping national orders violate procedural due process or the limits of emergency authority. The legal landscape may soon split into circuits interpreting the order differently, provoking intense legal scrutiny. Moreover, public pressure, political backlash, election results, and legislative responses could reverse or modify any order. Ultimately, it could become one of the most consequential constitutional conflicts of this generation. 7. The final uncovered revelation, a deep secret from court papers. Now for what I promised. The final revelation, the kind of bombshell detail that's not being widely reported. Insiders suggest that the emergency motion before the court secretly references a previously sealed internal draft opinion that proposes phasing out permits over a 3-year window, not immediate abrupt voiding. In that draft, the court would permit states to reapply weaker permit systems under a narrow federal standard. That means the headline, "End all permits now," might be a dramatic cover for a more gradual, legally cautious rollback. If true, it reveals strategic judicial craftsmanship. The justices might seek to avoid chaos by allowing transitional rules. This means the public must watch the fine print, not only the headlines. That hidden draft, quietly circulated among clerks, could be the real lever. If the court ultimately enforces the softer version rather than the radical wipeout, states might be able to negotiate how they re-regulate permits, but only under new, stricter constitutional constraints. That secret draft is the smoking gun that suggests this isn't a raw power grab, but a radical rewrite of federal-state boundaries in gun regulation. So don't forget to subscribe, like, and leave your comment about what shocked you most about this decision, and I'll see you in the next video.